Hello students. Be ready for the dictation. Start. 4. The plain reading of the aforesaid FIR would indicate that the appellant and his family members are alleged to have demanded dowry and thereby caused mental and physical trauma to the first informant. As stated in the FIR, the family of the first informant had spent a large sum at the time of marriage and had also handed over her strethan to the appellant and his family. However, shortly after marriage, the appellant and his family started harassing the first informant on the false pretext that she had failed to discharge her duties as a wife and daughter-in-law, and also pressurized her for some more dowry. The appellant is alleged to be an alcoholic and used to regularly raise his hands on the first informant and treat her inhumanly. Allegedly, upon complaining to the appellant's father and mother, they would take the side of their son, that is, the appellant herein, and would pressurize the first informant to get something more towards dowry. The first informant has further alleged that her sister-in-law used to harass her for a diamond set and would threaten that failing to get one, she would be driven out of her matrimonial home. The first informant was serving as an assistant professor and has alleged that the appellant and his family would keep her entire salary. The appellant would assault her whenever she would ask for money, saying that the first informant should ask her family to bear her personal expenses. It is also alleged that the appellant was having an extramarital affair with one another woman and he would threaten the first informant with dire consequences had she told anyone of his affair. The appellant continued with the extramarital affair for a long period and later filed a divorce petition in July 2019 on absolutely false and baseless grounds. It is further alleged that during the initial days of the COVID-19 lockdown, the appellant disconnected the water supply at their matrimonial home and took away their minor son. In such circumstances, the first informant was left with no option but to leave her matrimonial home and return to her parents. Efforts were made for some settlement, however, the appellant and his family kept on insisting for more dowry and also refused to return her strethan. Para change. 5. Upon the FIR referred to above being registered, the police carried out the investigation and proceeded to file charge sheet dated 13th October 2021 only against the appellant herein. A closure report was filed against the remaining 4 accused. The filing of the charge sheet culminated in the criminal case in the Court of Judicial Magistrate, First Class, Hisar. The appellant herein went before the High Court with a quashing petition for the purpose of getting the criminal proceedings quashed. The High Court vide its judgment and order dated 5th April 2022 declined to quash the criminal proceedings in exercise of its inherent powers under Section 482 of the Criminal Procedure Code, 1973. It is now well settled that the power under Section 482 of the CR.P.C. has to be exercised sparingly, carefully and with caution, only where such exercise is justified by the tests laid down in the section itself. It is also well settled that Section 482 of the CR.P.C. does not confer any new power on the High Court, but only saves the inherent power which the court possessed before the enactment of the Criminal Procedure Code. Thank you, students. Over.